Our next case is Vectren versus Department of Treasury. Good afternoon. This is a 15-minute mini oral argument on the application. You have 2 minutes of a free fire zone, and you may reserve time, but that we ask that you keep track of your own time. And you can begin when you're ready.
Well, thank you, and may it please the court. Good afternoon, Your Honors. Assistant Attorney General David Thompson here on behalf of Treasury, and with me at counsel's table, Assistant Attorney General Justin Call, and I would like to reserve 3 minutes for rebuttal. Your Honors, we're here today because of the undisputed and significant connections between MLI's business operations and our state of Michigan, and its own business decision to sell during the time period in question. Based on those connections, Treasury applied the Michigan statutory apportionment formula, which is rebuttably presumed to be true and fair, and states are entitled to great latitude to devise such formulas despite imperfections, for which reason Vectren bears a heavy burden to rebut the formula's presumed constitutionality. The formula must stand unless Vectren has shown by clear and cogent evidence that it causes gross distortion. And what evidence do we have here, Your Honors? Quite a lot, actually, to indicate the significant business activities and opportunities here in Michigan which support application of the statutory formula. There is little, if any, evidence to the contrary. Off-point overgeneralizations, characterizations, and information penned from an attorney-prepared letter do not amount to evidence of distortion or provide a basis for alternative methodology. Further, the Court of Appeals erred when it effectively forced Treasury into a negotiation with Vectren and then would purport to craft its own remedy in the event that that negotiation stagnates. This presents separation of powers problems and is contrary to the statute, which provides that it's Treasury's exclusive authority to approve an alternative method. So I propose the following rules for this court to articulate. First, the question of whether statutory apportionment is constitutional requires examination of current connections, the current snapshot in time, a single tax year, and applying this principle here, the statute is constitutional. And second, Treasury has the exclusive authority to approve alternative apportionment subject to judicial review. Now, concerning the question of gross distortion, Vectren has failed to meet its burden of proof based on what we know about its activities here in Michigan and the transaction at issue. Now, as an initial matter, the purchase price reflects current and forward-looking opportunities. So if you think about a buyer and a seller and a transaction, no buyer purchases a business because the seller had made money in the past. They buy the business because they believe that business will make them money going forward, and the purchase price reflects this. There's a premium paid for such things as goodwill, which is, again, it's a current snapshot in time that nevertheless captures the forward-looking opportunities associated with that transaction, and that's what happened here. MLI made a business decision to sell during the time period at issue, and the timing of that decision does not appear to have considered the question of taxation. All they knew was they had a willing buyer for the right price, and they simply wanted to get the deal done. And now they want special tax treatment. But we know that they had significant business activity here in Michigan, serving such customers as Consumers Energy and Enbridge. And the evidence shows that they were also well positioned to benefit from increased unconventional gas and oil production, including in the Antrim Shale Basin, which for those folks like myself who were not familiar with this industry, the Antrim Shale Basin actually encompasses the entire state of Michigan, which their own offering memorandum proposed that this was right in the, quote, geographical sweet spot for MLI. And some of the evidence propagated by Vectren, which I'll note very quickly, some of the evidence attached to the briefing was not attached below, so that, as a matter of law, should not be considered by this court. But if the court is going to consider it, it's propagated to show distortion, but in fact, it shows the opposite. So, for example, we have personal property tax returns, and these indicate significant machinery and other assets located in Michigan during the tax year at issue. There was also a draft valuation report of MLI's intangible assets, but that report did not value other types of assets or do it on a state-by-state basis. Likewise, the nearly
Let me
five...
ask you a question here. Do you agree that the Supreme Court of the United States labeled the three-factor of property payroll sales as the widely accepted model for taxation attribution? And called that the benchmark against which other apportionment formulas are to be judged?
Your Honor, it's absolutely an accepted method, that three-factor method. However, the single sales factor also has a lot of pedigree, including from the U.S. Supreme Court. And the fact of the matter is...
So am I overstating it when they call it the benchmark?
Your Honor, I can't recall off the top of my head whether or not it was characterized as the benchmark. I can tell you that there are at least 20 states that apply a single sales factor, which is presumed to be...
And do they do it in a short period, like the 3-month period we have here?
Your Honor, I'm not aware of any facts that limit it to that period in time, but it is presumed to be fair.
Should that make a difference?
I don't believe so, Your Honor.
Why not?
The reason is because the question of sales, as again, the U.S. Supreme Court has determined, and I'm looking here in particular at Trinova, the question of sales is the best metric for business activity. Further, a single sales factor is very easy to administer. So you have identifiable numbers. It's easy to discern what the numbers are, where they come from. And the pedigree in terms of the fairness and appropriateness of this factor formula is well established.
You mentioned Trinova, and Trinova, didn't the state use a 3-factor model for taxation?
So I believe Trinova was a 3-factor model, Your Honor.
Counsel, I think sort of related to all that, I mean, we know there's the statute built in this rebuttable presumption, but it also, built in a way to say it's not fair. Is there, what would be an example of something that wasn't fair? Like what could, take this case, what could have Vectren brought to the table that you would have said, yeah, we agree, we have to do an alternative formula?
Sure, Your Honor. Well, there are examples of this, and I'll throw one. The Norfolk Southern case is an example of this, right, where you have rolling stock and you have a certain amount of train cars in a particular state, which was Missouri, and the taxpayer was able to prove conclusively, hey, we only have so much train car rolling stock in the state during the tax period at issue, and that's another important piece of this, during the tax period at issue. So the showing there was we have a discrete amount of business activity, rolling stock, but in that instance, Missouri taxed it at a much higher level, devoid of evidence. So in that case, the rebuttable presumption that you note, the taxpayer came to the table and said, this does not reflect our business activity, and then the taxing authority didn't have anything to say in response. So that's an example of showing, okay, your business activity is at a certain level, contrary to what the taxing authority had otherwise determined. Here, the undisputed facts are they put it in their own returns. They had this business activity in Michigan during this period. So as a matter of fact and law, there is no distortion.
Well, they put it in there, but then they also put it in the denominator, right? So it sort of canceled itself out.
They did put it in the denominator, and the purpose of that was, as you say, to dilute, right? To dilute the fact that it was in the tax base.
Let me ask you this question. Are the sales factor, these apportionment methods and formulas are supposed to help us determine the extent of their business activity in the state. And you've come up with a sales factor of 70%, which you've applied to the proceeds from the sale of the entire company. So am I looking at it wrong if I understand your position to be that you believe that 70% of the value of the company is attributable to its operations in Michigan?
It absolutely is, Your Honor, and especially
How can that be?
Because when you look at the tax period in issue, that is exactly the business operations that they had here in Michigan. So
they don't have any permanent facility here, right? They brought in a couple pieces of equipment to work on one project. That made up a small portion of their overall income for that 1 year, or that one, right? Did I have that right?
So, Your Honor, for that year, it actually brought in a significant amount of income, and that amount of income is undisputed. It's
way less than 70%, right?
No, I believe, Your Honor, that the apportionment percentage reflects the business activity that they had here in Michigan. So the
You
question
think
is,
70% of their, I mean, maybe for that, you were reducing it down to that 3-month period? Is that what you're doing?
so we are just looking at that 3-month period, but Your Honor, if you want to look beyond and look at the rest of the year.
I'm trying to understand how this doesn't create a huge windfall for you. They sold their company, which is based in a different state, which has all of its physical property, facilities in other states, most of their employees in other states, and does most of their business in other states. And you're telling me that because they did one project in Michigan, 70% of the value of the company is attributable to their activity in Michigan. On its face, I just have a very hard time. Do you have is there a business valuation expert that would say such a thing? I mean, it's hard. I have a very hard time with your position in this
So,
case.
Your Honor, it's not limited just to the one project. They also had developing opportunities here. Their second and third largest
I
customers
mean, so they
were-
might do business here in the future someday. You know, when people sell a company, value a company, I think, I mean, I sort of beg to differ with you that I don't know, people obviously want to make money in the future, but they determine the valuation of the company based on its past performance, I think, because that's all you have to look at to try to use as a guide to how you think the company is going to perform in the future. Is that not true?
Well, Your Honor, it certainly, you know, the past plays a role in developing what the current value is, but that current value, think
They
of
look
like
at things like EBITDA, and then there's a multiple they apply, and that comes up with a valuation of the company. That's what all these experts do, right?
Right, and Your Honor, that can get very complex, but in this case, the rules that we're articulating for you make it very, very easy. We're just looking at the one snapshot in time. So in that.
I know, but why isn't that a distortion? If you take away all the context and we put our blinders on and look at this one little snapshot, this company that has historically done very little of its business in Michigan should have to pay tax here as though all of its value, or a huge percentage of it, 70%, is attributable to Michigan. I mean, it's hard for me to understand your position.
And
Well,
Council,
so-
wasn't the year prior, wasn't it 40 million in revenues?
It was, Your Honor, so they had been ramping up their productions, and also, by the way, going back to Justice Viviano's questions, they would go on to make another $40 million in the remaining months of 2011 as well, and their second and third customers, largest customers, right, were here in Michigan in that time period as well. So it's not limited to just this one project that they had, this Kalamazoo cleanup. There's a lot more going on here, but in any case, the rules that we're articulating are, it's breaking new ground, and indeed, the Court of Appeals broke new ground when they said we need to look to history. No court has ever said we're going to look at the current snapshot in time and tax this tax year based on history. That's a brand new determination. We're asking.
Well, we're looking at the proceeds from the sale of the company. That makes it a little bit different than the typical work that you do for the state, which is looking at somebody's income from that year, right?
Your Honor,
income from sales or services provided, whatever it is.
It may not be typical, but it's not uncommon either. So the Kraft Group case would be an example. There are other examples where there are lines of business that are sold off. Sidney Frank is one that's coming to mind. I see that my rebuttal time has been taken up. So if there are no further questions, I'd like to reserve the remainder.
Yep, that's fine.
Thank you.
Thank you.
May it please the Court, Lynn Gandhi from Foley and Lardner on behalf of Vectren Infrastructure Services. This case does not meet the standards for leave for review. This case is so factually specific to a very unique set of circumstances, a short year, a sale of a 52-year-old company, doing a unique activity during its normally idled 3 months of the year, facts probably never to be repeated again. This does not rise to an issue of major significance in the state, particularly as the statute.
This is the new tax, I'm sorry, your time, you can go.
No, I would much rather take the questions from the court.
This is significant. This is the new tax that applies to all other businesses moving forward. If this was the old tax, I'd agree with you, it's not significant, but this is the first interpretation. And you want us to just leave it in place with the Court of Appeals? This is the type of case exactly the type of case that the Supreme Court should be looking at.
Well, it always warms my heart to hear that the Supremes would like to take more tax cases. But I believe, Your Honor,
Justice Sorrow was the only one that said that.
I think I said that before.
I believe this court could address it on an order. I don't necessarily, I believe that is the significance, and based on the questioning I've heard, The use of a single sales factor methodology on its own can be constitutional. That was that has been held by the Supreme Court. But with no factor representation, so I want to make a distinction. It's not about the single sales factor. It's the fact that we know constitutionally we must have fair apportionment. And if you tell me that there's no representation at all in the factor, then that is an apportionment, right? In Michigan, it's the disconnect between the single sales factor and the tax base. And if you have it in one, you have to have it in the other. That is the latent inconsistency that is causing this distortion. And then an alternative is provided for in the statute. I believe the taxpayer has met its burden by clear and cogent evidence. This is not an error-correcting court. The Court of Appeals twice decided that the record was complete and sufficient. I'm a bit bewildered by Treasury's allegation that they lack any evidence in order to come up with a reasonable alternative. They've audited this client. They have a decade worth of tax returns. They have the federal tax returns. They did an audit and assessed $2 million. Their own audit work papers are resplendent with plenty of information understanding this taxpayer. And that's why I believe in order requiring factor representation or in order determining that the record is sufficient could handle this case. But it is correct. It's a very unique set of circumstances. We have 70% of the gain being apportioned to the state based on 3 months of activity. You know, there was some discussion about the rest of the year they made a lot of money. They didn't exist the rest of the year. They were sold.
Were any assets sold in the MLI acquisition, whether it be employment contracts, facilities, goodwill, any asset at all, owned in Michigan?
Yes, and in fact, this reference to the Michigan personal property statements, which were filed, there was roughly $263,000 of personal property in Michigan at the time of the sale. The personal property renditions were provided to evidence the specific amount of property in Michigan at the time of the sale. That is the extent of their property that was in Michigan. I think a few people were working here. Most of their labor they hire at the local union shop. They only have a few supervisors come in. No permanent establishment. $263,000 worth of equipment is not a lot of equipment for a company this size. That's what they had here. And more importantly, in the decade prior to the sale of this company, they had only earned 6.9%, an average of 6.9%. You know, Justice Welch, when you brought up the $40 million, if that's the net income, it then is apportioned based on the factor. Michigan uses single sales factor. So they would put Michigan sales in the top, total sales everywhere. That percentage is then applied against the $40 million, their net income. What happens here, though, is because it's not just the single sales factor, it's because Michigan says there's nothing in the factor. The gain goes in the base. There was no factor representation here. It's because we have these somewhat strange definitions of business activity, taxable base, and then how we compute our factor.
Well, it's interesting because as I recall, the big debate when the MDBT was getting passed is it was supposed to simplay things.
I
recall
know
that debate very clearly.
It has simplified a bit. Well, I should say this. The MBT helped us simplify because going through that experience was such a horrible experience for everyone here in the state, particularly small business owners. We learned what not to do again.
So I have to admit, the one thing, I understand sort of this fairness argument. I understand this is a big number. I mean, it is. I'm really struggling, though. We do have this United States Supreme Court precedent that makes it pretty clear that if you're taxing a unitary business operation, a sale can be taken into account in the formula. So I'm trying to figure out how do we reconcile that?
Yeah, the reconciliation is, I'm not arguing about the formula, the sales factor formula. Agree to sales factor. The problem, though, is how Michigan defines the sales factor is sales in Michigan would go in the top. and all sales would go in the denominator, the bottom. This gain on the sale of the company, Michigan says, we don't consider that a sale. It's not in the factor at all. They want to put sales from their operational activities in the
Right, because
top.
of how
Right.
sales in the traditional sense, you're selling a service, you're selling a
Right,
good.
you're selling a service. It's not sale from the gain of a sale. So you take this big behemoth of a number, the gain on the sale of a historical company, you say that's what we're going to divide up. And how are we going to divide up that gain on the sale? And you don't put that sale in the denominator. Think of it as if you brought in a birthday cake for a first grade birthday party at school. And everybody's going to get a piece of that cake. So you have 32 kids in the room. And you say, okay, normally you would say everybody gets 1/32, maybe 1/33 so the teacher can have a piece. But what we're doing with our statutory method is saying, if your gain on the sale was half those kids in the room, for that year, your gain from the sale was about 70% of your total sales. You're saying, I'm going to take 70% of those kids, put them in the hallway, and the ones that are left, they get to divide up that cake. That's what's happening here. It's not because we use a single sales formula. It's because we're not putting the gain on the sale in the denominator. We don't consider it a sale at all. So we're dividing up a really big number earned in multiple states over 52 years, and we're saying Michigan gets to take a snapshot for 3 months based on one contract. And in fact, our own statute recognizes sometimes our standard methodology isn't correct. It's not fair from a constitutional perspective of fair apportionment. So we provide for a process by you can ask for an alternative. That's what we're contesting here, is the disallowance that we believe we met the standard. Clear and cogent evidence, proved gross distortion. It was simple math. We're simply asking to utilize the apportionment methodology that's provided for by statute, which interestingly has been on the books, I believe, over 25 years, and maybe has been granted once by Treasury. This indeed is a case that qualifies for having met the evidentiary standard and then proving gross distortion.
What if the sale had happened at the end of 2010?
Perhaps the distortion would not have been as great. We don't know. It didn't. We don't know what would have occurred in Michigan. We don't know what would have occurred elsewhere. I do agree with you that I believe if the sale had closed on December 31st, maybe none of us would be here. This distortion might not have been gross distortion. Maybe it was a little distortion, which the Supreme Court allows, the U.S. Supreme Court allows. But gross distortion, it was over 400%. We might not have been here today. I can't say because I can't crystal ball.
Do you know if other states do this as well?
Yes, almost all states. So we have something called Dep't, the Uniform Division of Income for Tax Purposes Act. Almost every state statutorily provides for alternative apportionment pretty much on the same standard. We call the standard Dep't 18. You have an evidentiary standard.
Right, so I understand they have the
Yeah.
alternative system.
So yes, most states do.
But I'm
We
also
are n-
wondering if others will, how they would allocate the sale of the business, where they would put that
So
in the
interesting you
formula.
bring that up. Many states have provided guidance. Michigan actually has draft guidance prepared, being held pending this decision. Most states will say, hey, when you sell a business, you're not selling one thing. Let's unpack it. Most states say sale of the intangibles, the goodwill, the safe workforce, those are intangibles. Those get allocated to state of commercial domicile because that's really where a company manages its intangibles. Physical assets, real property, those get allocated to the state in which the property is located at the time of sale. So many states have detailed statutory language that goes through and specifically describes when you have that sale. Michigan just says all income is business income, subject to Supreme Court constraints, and I believe our Sarco and Mobile here clearly show Hans Rees that this is a case where you cannot allocate intangibles. the KPMG study talked about 4 major categories of intangible. Safe workforce, the fact that they had a good reputation in the workforce. Those were intangibles that were derived from them doing the activities predominantly in other states over the past 52 years. And Michigan wants to tax 70% of that. The company filed tax returns in all the other states. They paid income in all the other states. The department was provided those returns in discovery at a deposition based on a motion to compel. They are aware that this is not a circumstance where a company escaped taxation or is trying to create nowhere income.
So just to be clear, they're repeatedly paying state income tax on the same income in multiple states.
Yes, they are, based on every state's apportionment formula, how they,
Well, I mean, to the extent that Michigan's taking 70%, they're probably paying,
right,
300
over, particularly because this was an
350%.
S Corp. So the tax in most states, not MBT, but in most states, was paid by the siblings. And now on top of it, a state wants to take 70% of the tax at the entity level.
Is it fair to say that this, because of the way Michigan is set up now under the new MBT, that often the sale of an out-of-state company will require the alternative approach?
I would not say that, because, again, the burden of proof is quite high. There's a couple recent cases out there in other states where it's clear, South Carolina, whoever makes the allegation carries the burden of proof. If Treasury says, we want you to use an alternative method, we don't like the statutory method, which other states have done, then Treasury would have the burden of proof. So in general, most taxpayers do not automatically go to seek alternative apportionment because it's costly. You have to do a lot of computations off the software. You have to seek the permission. It can become litigated. You have to hire lawyers. But when there are issues of gross distortion, there may be applications. We don't know how many applications Treasury actually gets every year. But, it's not an avalanche because the average taxpayer follows the software, goes through the process. But this is a unique set of circumstances. I can't tell you it's never going to happen again. In fact, I find it strange that it shouldn't happen on a somewhat consistent but not major basis that taxpayers, we have a process. And indeed, I believe because of this case first being filed, Treasury finally issued some guidance on what is the process. It's clearer now, it's more straightforward, they tell you what you need to provide. And Vectren did provide all that. We're here today because we met that evidentiary standard and there was gross distortion. The lack, I'll just say final, the lack of any factor representation, again, this isn't about single sales factor. This is the fact that it's in the base and not in the factor at all. This court could cure that latent defect by order without further remand and require factor representation. And that might even disparage other cases coming before you on this very same issue.
But counsel, the statute is pretty clear. It says only Treasury has to approve the apportionment formula.
Approve. Doesn't mean that they're the only ones that can determine the alternative formula.
Thank you.
Well, Your Honors, just a couple quick notes in rebuttal. So a lot of the conversation has revolved around this idea of factor representation. I'd like to address that. So factor representation, there's a reason why when you look at opposing sides' brief on this question, there's a reason why you don't see any MCLs or case law citations for factor representation. Instead, they cite tax practitioners who are vested stakeholders in the matter. That's because there is no authority to support this idea that there must be factor representation. It's very clear. We look at the question of internal consistency, which is to say if everybody taxed what Michigan did on based on the same formula, would more than 100% be taxed. And Your Honors, I'm just going to read in alphabetical order some of the other states, the amount of tax that was paid. So Colorado, $0. Georgia, $0. Iowa, $243. Okay? Indiana, $186. They talk about Minnesota. Minnesota imposes only a franchise tax in the amount of $5,000. Your Honors, this formula was more than internally consistent. in this particular case. I'd like to touch a moment on Justice Welch's question. So the court's last question is effectively a separation of powers question. First, the court cannot force Treasury into negotiation with taxpayers over against the dictates of the statute. Your Honor, I agree with that completely. That is legislative activity. Neither can the court craft its own remedy. That is executive activity. Imagine court clerks, right, poring over valuation statements and tax returns to come up with a proper percentage. This court all the way back in the case of Hausman, 1885, looked at this and said this is not judicial activity to have tax authorities go out. Judicial authorities go out and essentially do tax work. That just does not make any sense.
Can you go back to the states that you started listing off? Are there other states that they had tax liability that have higher numbers that you didn't share?
Sure. So North Dakota, $8,216. That's the highest on this list that I have.
The highest
here.
on the list is $8,000.
That's what I have on this list according to our analysis, Your Honor. And then Illinois, $4,000. I mentioned Minnesota, $5,000.
Thank you.
In closing, what Vectren seeks here is something that this court rejected in Trinova, which is an all-purpose tax equity provision. Your Honors, there is no such thing and there's no basis for special treatment in this case. The rules that we articulate for you today preserve the statute's substance and procedure, and they also accord with Michigan's constitutional structure and separation of powers, and they accord with the statute at issue in this matter. For which reason we ask you to affirm Treasury's assessments, its authority, and the integrity of this particular taxing statute.
I actually have one more question. Let's just take North Dakota. I'm going to make a guess that it's probably a low taxation state for their policies for these sorts of businesses. What if they had the exact same kind of formula we have in Michigan?
So, Your Honor, if they had that exact same formula, we'd look at what their business activity is in North Dakota. So you're looking at the total business activity. If 70% was in Michigan, there can't be more than 30% across all of the other states combined. So if North Dakota did it the same way, perhaps 1% of their business activity was in North Dakota, the sales factor would reflect that, and it would have to. Mathematically, it can't add up.
But would your tax base, as far as the sale of the business, still be the same?
The tax base may be the same, but I'm not quite sure what their taxing scheme is.
Sure.
I mean, we defined ours, in this case, it was gross receipts and those other things, but the sales percentage would still reflect internal consistency as
Right,
it has to.
and the reason I think one of your more compelling points is, look, they didn't pay, this was the only place they had a big tax bill, basically. So I hear you on that, but I'm sort of wondering, but what if another state had the exact same, treated the sale of the business the same way, because under their tax scheme, they could do that. I'm just wondering how that would, I get it, it happened in the 3 months while they were mostly working here, I understand that, but I'm just sort of wondering, sort of this notion of the fairness piece, are they getting overtaxed as on the sale of the business?
Absolutely.
And you're saying, no, it didn't happen here because they paid low taxes everywhere. But what if other states had a scheme similar to Michigan's?
Yeah, so Your Honor, we can't really say, I mean, three-factor, as Justice Zara had said, three-factor is something that's acknowledged, right, as a fair formula. I'd look to the Mormon case, also this court's Trinova case, in terms of both three-factor and the single-factor. In both instances, it's well established that they're both fair and they're internally consistent. So mathematically, it can't work out otherwise, but I mean, it would require an analysis of the tax-based scheme, the tax-based composition, state by state, to really answer that question.
Okay, thank you.
Thank you, Your Honors.
Thank you. The case will be submitted.